The Gauteng government says it will approach the Constitutional Court to challenge a ruling by the High Court in Pretoria. Now, the High Court overturned Cooperative Governance MEC Lebogang Maile's decision to dissolve the Tshwane Council. Judge President Michael Mtambo declared the decision unlawful and set it aside, accusing the provincial government of interfering in the affairs of the metro. An administrator has since been appointed and fresh elections were meant to take place in about 3 months. Well, MEC Maile is on the line to us now for a bit more on this and the other relating issues. MEC Maile, thanks very much for your time. Welcome to Newzroom Afrika. A part of what you had stressed yesterday was the need for clarity around this issue. And perhaps as a start, let's get an idea of what clarity exactly you are seeking as you take this appeal to the Constitutional Court.
Okay, maybe firstly, good morning. Thanks for having us. The first thing we should clarify is that this is not my position. This is the position of the Provincial Executive Council, meaning the provincial cabinet. So that's very important because I know that even the DA has been harping on that point and saying it's my position. I don't have the power to make such a decision. Such a decision can only be made by the Provincial Executive Council. So that's very important. And it's fundamental as well.
Sure.
It's the case, yes. So that's the first point. And the second point is that we are saying there are a lot of issues that the judgment raises, which in our view, we believe they actually cause more confusion instead of giving clarity. And the first thing is that the judgment imposes 2 additional requirements to Section 139 of the Constitution, and that is the section that we used to make a determination. That section has got 3 provisions. The Section 139, subsection 1, A, B, and C. And what it means is that if it's A, you can issue a directive. If it's B, you can assume responsibility, certain responsibilities. If it's C, you can dissolve. So we started with A at some point, and then we ended up with C. So that requires the Constitutional Court to clarify if indeed the High Court was correct to impose 2 new requirements for the dissolution of the municipality. So that's the first thing. And what it means in simple terms is that the Constitution is being amended, and we are saying the High Court does not have that authority to amend the Constitution, and hence we would ask the Superior Court, in this case the Con Court, to give clarity on that issue. But the second issue, we're saying the fact of our case, which remains solid and germane, such as the dysfunctionality of the Tshwane municipality, because even the judgment itself acknowledges that the municipality is dysfunctional. So amongst other things, we want and it also admits, for instance, about the crisis of service delivery, in particular about water provision in Tshwane. And then we also believe that the judgment has completely ignored the overwhelming evidence that we have presented there. But the court also raises the issue about the executive obligations of the municipality. And it says that it does not agree that the reasons we gave are executive obligations, except the 2, which I have just mentioned here. But and I don't want to enter into a legal argument because it causes more confusion, because one of the reasons they agree with is related to service delivery. But the issues we raise are related to service delivery, but they are saying those are not executive obligations. So we are saying we seek clarity. We want to understand so that this can help us in the execution of our responsibilities beyond the Tshwane issue. And it will also help other provincial governments, because there's a lot of judgment all over the place by different courts on same matters, but different interpretations. So we believe that the Concord should be able to make a final determination as the final arbiter on the issues of the Constitution. That's why we have sought a relief directly to the Concord, and we hope that they will not refer us to the Supreme Court of Appeal, because we want to bring this matter to finality once and for all, so that the people of Tshwane can know what is happening.
And we'll speak about that in just a moment, but let's stay with the issue around, those constitutional or executive obligations. I mean, the High Court essentially found that some of the legislation that you had cited had been a bit vague. I mean, my understanding is that you cited Section 15 of the Constitution, Section 11 of the Systems Act as well, in trying to point out some of these deficiencies. In hindsight, do you believe perhaps you may have not been as thorough as you could have been in explaining those obligations and what objective you're actually aiming towards? Speak to us about the critique, essentially, that part of your answering affidavit was vague.
Yeah, well, that is remember, hence our contention that the judgment itself is riddled with a lot of inconsistencies, a lot of contradictions, and that's our contention now. And we believe that let's take this issue to the Concord, to a Concord, because as far as we are concerned, we did our level best through our legal counsel to demonstrate that our decision is lawful, and the reasons that we are giving are solid. So we are of the firm view, with due respect to the court, because we don't, and I think this is a very important point to make, we are not questioning the authority of the court, and that's why we are proceeding to seek clarity from the highest court in the land, and we will be bound by whatever decision that the court is going to take. So that is very important to understand. We're not appealing because we undermine the authority of the court. No, it's because we are confused by the judgment. When we look at it, we think it will. Some of the judgments are unworkable, and it will make our work very difficult in interacting with the local municipalities and in doing our oversight work. So the same reasons that you are advancing are the same that we are using to go to the Concord.
So the court has also found, the High Court that is, that perhaps, moving to dissolve the council wasn't the next natural step, considering what had already been done until that point. For instance, they point out that they feel a lot of the councillors in Tshwane had prioritized party politics ahead of obviously trying to ensure that there's service delivery in that area. Now that this has been raised in this form, do you feel that there could have been a few more interventions before moving ahead to the dissolution of the council itself? How best could we have addressed, for instance, that particular issue before moving on to rope in an administrator?
Yeah, but it assumes that there were no interventions. There have been interventions before, and that's the point we're raising, that there's more confusion, because firstly, we have been interacting with them. Even during the times of MEC Mashatile, before I was MEC, there was MEC Muiba, before I was MEC. We have interacted with the municipality. There has been issues of the municipal manager, issues of corruption, there's been issues of other law-related issues. I myself have met with the mayor, have written several letters to the municipality. We have made several interventions. So the intervention does not even start last year. It started since 2016 when the municipality came into place. So that's the first point, that it's not starting now. So the assumption that we did not do enough, it's wrong to put it blindly. Yeah. That's the first thing. But the second thing, it's mechanical to say you could have done other things and not this and all that, because what happens is things have collapsed completely. You say, no, let's wait until there's nothing. So that's the second point. But the third point is that this issue of party politics, by the way, if you look at the judgment as well, it's a bit one-sided. We are not saying the walkout did not contribute towards the collapse, but there was also the issue of the collapse in relationship between the parties that were in a coalition, and fundamentally that started the problem. And then the fourth issue has been the overlooking and disrespecting of the council rules by the speaker, amongst others. So there's several reasons why council has collapsed, but unfortunately the judgment emphasizes why. So I'm saying to you, that's the clarity we want from the court, so that we are able to move forward and avoid the mistakes that the Tshwane Council has done in other municipalities going forward.
So, MEC, then, given, I guess, the spirit of charting a way forward, why should residents in Tshwane still continue to put any confidence or trust in the provincial government, considering how protracted this has been, considering the back and forths that we've all been subjected to, and considering the many times that decisions have had to be relooked and reevaluated? I mean, one can imagine the frustration that must be building up in many Tshwane residents who face now months, really, of just lackluster service delivery, if any.
But the provincial government is not responsible for the problems in Tshwane. So the issue of why should they trust the provincial government does not even arise. The issue is why should they continue to trust the municipality.
But the decisions of the provincial government have been questioned more than once now, and in instances where there's a deadlock within the municipality, it is the provincial government that steps in. But even those interventions haven't been able to solve the problems as quick enough as we need them to be solved.
That's because they have been frustrated, among others, by this same judgment. They've been frustrated by politics and which other decision? Because that's the position of the DA, by the way, what you are advancing, to say our decisions have been wrong. Which decisions? Because let me tell you, there was an issue when we acted against the speaker, because the speaker was disrespecting a council and placing herself above the municipality. We were told by the DA that we are wrong, and they cited a case in one of the courts in Western Cape, and we were proceeding with disciplining. Our senior counsel said, in terms of the code of conduct, we are correct. It's not explicit in terms of what process you must follow, but that case, which was a judgment, stipulated that a certain process must be followed, which meaning that the matter must be taken back to council. We did exactly that. We took the matter back to council. In this case, the same DA argues that we should not follow that process. We should discipline ESF and ANC members. So why do you blame us when we are being frustrated and games have been played and all that? And that's what I'm saying to you. The issue of the credibility of provincial government has not arrived. In fact, we're proving that we've done everything that we can. So if the Concord says we were wrong in intervening, we have intervened. And I've said in the press conference yesterday, if we give us space, so you are damned if you do something, you are damned if you don't do anything. So we are not going to fold our arms and be scared that we will be accused of this or that. We're looking at the law. The law says we have a responsibility to do oversight in the municipalities. We have a responsibility to intervene if there are problems. We have a responsibility to support the municipalities. And that's what we are doing. In the process of doing that, if there's a problem that arises, we will from time to time not shy away from going to court if there's confusion ourselves. So don't create an impression that the provincial government just woke up and created problems in Tshwane. There's been problems in Tshwane as a result violation, and that's what we are saying.
Okay,
so,
sure, no.
And that was unavoidable. So,
right.
so please be objective in how you deal with the matter so that you don't confuse the matters. Because what we are dealing with here is a dysfunctional municipality that is not able to deliver services, and we are intervening.
Okay, MEC, the point is well made. Thank you very much. Sadly, we've run out of time. I completely hear that, and these are just some of the issues that have been raised by some people who are residents there. It's certainly something we're not going to be able to exhaust now, and certainly more than happy to be able to ventilate it at a later stage. But for now, let me thank you. Certainly appreciate your time and your insights. Lebogang Maile is, of course, the MEC of Human Settlements here in Gauteng.